Eric is here and
You are now live.
Here, and we are now live. So we are, now that we've got the staff that can help us, is Eric, you were going to walk us through the life tenancy or extended life tenancy. I mean, I know what life tenancy is in real estate, but I wasn't here when that one went through, so if you can just, and I don't think anyone else was, so if you could just walk us through what is the original life tenancy, what did we change, and what will this bill change?
Yeah, this is Eric Fitzpatrick with the Office of Legislative Counsel. Thanks. Here to talk to folks about what's known in law as life estate deeds. I can certainly, Senator Cummings, talk about the first two elements of that. I don't have any knowledge of what this bill that you're looking at is doing. I was asked to come in and talk about life estates generally.
All right, that's fine.
Yeah. And so I'd be happy to provide the committee with some background about that. Unfortunately, my phone is ringing at that exact moment. Apologies for that. Yeah. So I'm just going to give that a moment. But yeah, so a couple of years back, the legislature passed an act that was called an act relating to enhanced life estate deeds. And what that did was put into law something that has been practiced for many years in Vermont with respect to probate attorneys who plan people's estates. And that's really what this topic is all about. It's what's known as a probate planning tool. So when we're talking about that, really, the discussion is about how to make sure that your property is transferred the way you want it to when you die. And it's a probate planning tool, just like a will is. So with a will, you make specific decisions about how you want your property to be transferred when you pass away. And the same thing is true for an enhanced life estate. It serves the same purpose. And so it's a topic that sometimes is difficult to discuss because it requires that precise knowledge in mind. It's why some people have trouble drawing up their wills. It really involves how it is a person wants their property to be distributed when they die. And the sort of one of the distinctive qualities of a life estate deed, as opposed to a will, your will, you can decide how you're going to transfer any of your property, right? It can be money, your life insurance policy, your personal property that you have at home. A life estate deed is used only to transfer real estate only. That's all it applies for. And it basically involves, it's a method to transfer real estate from a grantor, right? The grantor is the person who's transferring the real estate to a grantee, and the grantee is the person who receives it. And it happens by operation of law. That means automatically when the grantor dies. So as soon as the grantor dies, the property passes to the grantee, the person who has been named in the life estate deed as the recipient, the person who's going to get that property when the grantor dies. So the way it works, though, is that, ordinarily when real estate is transferred, say, a piece of property is sold from person A to person B, the transfer happens right then. When you execute the deed, the property goes from person A to person B, and it now belongs to person B. The property, when a life estate deed is used, it doesn't work that way. It doesn't transfer right then. The recipient, who's the grantee, only gets what's called a future interest, right? They don't have anything right now. They can't live in the property. They can't use it. They can't transfer it. They can't do anything. They only have what's known as a future interest. They have a future right to the property. And in fact, it's called, in legal terms, it's called a contingent future interest. And the reason it's called that is because it's contingent upon a future event happening. So if you think about that, that description makes sense, because what future event is it contingent upon? The death of the person who granted it to them. And it's only when that happens, and that exact moment that it happens, when the grantor dies, the property immediately becomes vested in that grantee. That future interest that they had becomes a present interest. They get it when the person who gives it to them passes away. So during the meantime, that person, the grantor, the person who gave that grantee the future interest, they get to have the same rights with respect to the property that they have all along. So they can live in it, they can transfer the property to someone else, they can execute a mortgage on the property, they can do whatever they want with it. And the grantee, that person who has a future interest, they can't do anything. They have to essentially wait to the moment in time when the grantor passes away before they get any right to the property. Now, as you can imagine, that is a tool that can be very useful for probate planning, for estate planning, when you're planning your how to distribute your property when you pass away, because ordinarily, say you use a will to transfer your property. Well, when you pass away, the will has to be probated, has to go through probate court. Usually you're going to have an attorney, you're going to have an executor appointed. There's going to be fees involved with opening the probate estate. There's going to be fees involved with paying an attorney. It's very time consuming. You avoid, and this gets to why this is used more and more, and the use of it is increasing as an estate planning tool. And it's happening more frequently because two main reasons. One is that it avoids probate, right? Doesn't have to go through the probate process because the property transfer happens as by operation of law instantaneously when the grantor dies. It automatically becomes the property of the recipient, the grantee, and they don't have to go through probate. No need for it. No legal need to hire an attorney, to pay probate court fees, any of that. So it's very cost effective and efficient way to transfer real estate. And most often it's done with parents and children, very frequently used. So that parents will grant their children a life estate in the property, but in the meantime, the parent still gets to live in it. So the parent gets to live in it for the duration of their life. And it's not until they die that it passes to the child or children. And that way they don't have to go through probate, open an estate over the real estate. It just happens automatically, particularly for people of moderate means who don't have a lot of property. Sometimes many of those folks, their home is their primary asset. Sometimes it's their only asset. And this allows them to pass that asset to a child or children without having to go through the time-consuming and potentially expensive process of opening an estate in the probate court. The other sort of function that it often serves, in addition to not having to go through probate court, the property that's transferred through a life estate deed is not subject to a Medicaid lien. So sometimes when a person is alive, if they're a person who is on Medicaid and they're getting Medicaid helping them to pay for their healthcare expenses at the end of life, those can be recoverable by Medicaid after a person dies in many situations, but a life estate deed is not one of those because the transfer never happened. It doesn't happen until the person dies. And because the property wasn't transferred during the person's life, Medicaid can't, it's sometimes referred to as the Medicaid clawback, but there's no ability of Medicaid to go back to that asset and use the equity to pay off the person's healthcare expenses. So that's another reason that it's used as a probate tool, and has been actually, just to sort of go back to H.8 37, what the legislature passed a couple of years ago. What I've just described as the process of a life estate deed has been used in Vermont for decades by probate planning attorneys. I'd say it's been used a lot more frequently as time has gone on, but it's been used for a long time. I just had a list. I think there's about half a dozen other states. I think Texas, Florida, North Carolina, West Virginia, about half a dozen other states have it as well, use it the same way. And so, the advantages of avoiding probate and not being subject to the Medicaid lien have always been the case. It's just that the reason I think that sort of motivated the passage of putting some of these practices into statute was that because it was really a creature of practice, and probate courts and estate planning attorneys, there were some different decisions about what sort of rights the grantor retained, which ones they didn't. There were some inconsistent court decisions on that. So to kind of make everything consistent and to provide predictability for the business community and for probate attorneys and for citizens who were transferring their property, the committee of the Bar Association and the Bankers Association and estate planners got together and worked on this language to try and make it consistent so that it was predictable for folks going forward. And that resulted in it being essentially codifying a practice that had been used by estate planning attorneys for quite a long time. So I think that's kind of the general description of what enhanced life estate deeds are and how they work. Happy to try and answer any questions. And I
one.
Yeah.
Senator Pearson.
Thanks, Eric. It sort of makes total sense, clear picture when you're talking about parents to a child in the case of, say, the family home. How does it work? Are these used when a house is jointly owned and then one spouse dies, or is that a different legal solution?
No, it could be done that way. And usually when that is done, the let's say two spouses were transferring it to a child, just to use that sort of hypothetical. Ordinarily, if one spouse dies, it still remains with the other spouse until the second spouse dies, and then it would pass to the child.
And in the meantime, does it pass from the two spouses sort of to the one spouse?
Yes.
Okay.
Yeah.
And in this case, we're looking at how and when the property transfer tax applies. So I guess we'll talk to Abby about some of those
I
details.
think that's what Rebecca's waiting to talk to us about. Okay, any questions on what a life estate is? Senator Sorokin.
Just one question, I should know the answer to this. Can you ever trigger a life estate on a third party's life, or does it have to be the owner of the properties who dies?
That is an interesting question, Senator Sorokin, and I think that you could create a contingency based on the life of a third person. And I think I have heard about that being done. So in other words, some property would transfer to some other person upon the death of a third party. I'm not sure it would be a life estate deed, because unless the grantor, structured it so that they would be able to live in the house. In other words, they would retain those rights of ownership of the property. Whether that would still be called a life estate deed, maybe it would be, because it would just be the life of another person, right? But I think you certainly could do a contingency. I have heard of those. You can do a contingent deed that is contingent upon the death of a third person, and that's when another person takes.
Okay, Senator Hardy has a question.
Thanks, Eric. You may have covered this and I just missed it, but the difference between a life estate deed and an enhanced life estate deed is there?
Yeah, it's really just the difference is that there are some not in Vermont, but there's some states do a life estate deed where you don't have the person who grants it, the grantor, under the enhanced life estate deed, they have some rights with respect to the property other than just living in it. They can transfer it to somebody else. They can mortgage it. They can even revoke it altogether and decide that they don't even want to give that recipient a life estate anymore. Some states have a strict life estate deed so that the only aspect of ownership that the owner retains is the right to live there, just to live in the house.
That's my,
So the enhanced refers to the rights above and beyond just living in the house that the grantor retains. Right of transfer, right of being able to give it to somebody else, right of mortgage, that sort of thing.
So in Vermont, we have enhanced life estate deeds, but not just vanilla life estate deeds.
Yes.
Okay.
Super subject.
we do life tenancy in real estate, which is really life estate. I sell you the house, but I get to live here until I die.
Okay.
I've had, actually, it was one of those grandmother houses on the property in Montpelier where it's actually Janet Ansell's son owns it. And the couple that built the little place on the property next door got to live in that until their deaths. So, and that's been around for a while. Eric, if I have a life estate and I sell the house, I assume that the life estate ends because I no longer own the house to have the ability to transfer it. And
Yes, that,
I mortgage it, the mortgage goes with it.
I think there were, might have been two separate questions there, but the
It
first
was.
question, yes, if you sell the house, then yes, you extinguish that life estate deed to the person who was going to get it. Yep, they no longer have it.
And if I put a mortgage on it, I assume that that mortgage also moves forward.
Yep, absolutely. You can still put a mortgage on it and that remains subject to the property, and it would still be attached to the property as well after you, if you hadn't paid it off before you had passed away.
Okay. Committee, any other questions? Okay, thank you, Eric. I think that now gives us a nice, clear framework to move to Rebecca and find out how we're gonna tax them. What
Well,
point, which is really
good.
our jurisdiction.
I'll listen in too, so I can hear about that. Thank you.
Okay. So
Great, thanks.
Rebecca,
Yeah, Rebecca Samaroff again, Deputy Commissioner at the Vermont Department of Taxes. That was a great intro, Eric. I actually learned a lot there. So this proposal that you see in sections 1 through 3 of our miscellaneous tax bill did come from the tax department. Since the legislature codified these enhanced life estate deeds a couple years ago, our practice has been to treat them just like other life estates for the purpose of the property transfer tax. And this is just codifying that in statute. It's also making an allowance for a refund, which is unique to these enhanced life estates, to reflect the fact that they can be revoked, unlike a normal life estate. I forgot what Senator Hardy said, but I like that term, plain Jane life estate. Vanilla, there we go. Okay. So it's really, there's two components of this language. The first just makes it clear that the tax base for the property transfer tax, like other life estates, is, or just the same method we currently use for other life estates, which is using these IRS tables that they publish every year to create this factor that considers the grantor age, the actuarial tables about their remaining lifespan, prevailing interest rates, all kind of mushed together into a factor that is how we value the value of the property that will be transferred in the enhanced life estate deed for the purposes of the tax. And then secondly, for these type of life estates, the person who pays the tax will be able to claim a refund of the tax within a year of any event that would revoke or revise that enhanced life estate transfer. And that's unique to these enhanced life estates. And that refund would have to be, or that event would have to be within 8 years of the original payment of the property transfer tax. And this is kind of a compromise of sorts with the real estate attorney stakeholders with the goal of clarity, I would say.
yeah,
I have a question.
I have lots, so
Oh,
go ahead.
okay. now I'm confused based on what we just learned from Eric. Because what I think I heard was that the property transfers when the person dies. And until that, then the property is owned by the original owner. So the property transfer tax would presumably be paid when the person dies, because that's when the property transfers.
Yeah, it's a very good question. It's a familiar question from various stakeholders, but the way this basically there's no way for the tax department to know when someone dies, and the transfer of the deed is actually like the taxable event for the property transfer tax. So when we've shared this with the Vermont Bar Association, for example, you know, their question is always around the same issue. Could it be paid at death instead of when this ELA deed is created? But that's really not feasible for the way the rest of the system works, because the property transfer tax, like part of why it's so effective is because it's due right at the point of that transaction. Like a town clerk, for example, can't record a deed without a property transfer tax being filed. So that's why, like, having just an event that is, you know, that we have some evidence of is important. But that's why we've added this 8-year allowance for a refund in case, you know, something happens after that transfer, and the taxpayer needs to get a refund because they won't end up actually getting the property.
Okay, so if I do a life estate deed to my kid and then decide, oh, actually, I prefer the other kid more, and I revoke it, and they've already paid the tax, they have 8 years that they could get that tax back.
I don't think.
Broadly, yes. I'll just use this example to clarify two things. First, that would be the enhanced life estate deed, because that would be the type that would allow you to revoke it. If it's a regular life estate, you're locked into that arrangement. Also, just a reminder that for the property transfer tax, a lot of these transactions are going to be exempt anyway. There's an exemption for certain family members, like a parent to child, for example, is a transaction that the property transfer tax wouldn't apply to. Spouses, grandparents to grandchildren, those are all exempt. So this comes into play in like very rare instances, I would say, when someone's creating an enhanced life estate to pass their home along to someone who's, you know, not one of those kind of more traditional relationships.
I see. Okay.
Okay, so right now what you're saying is that I set up a life estate for my faithful retainer. You know, when I die, my faithful retainer will own the house, not a family member. And right now, or they can live in it forever. It's not an enhanced estate. They just get to live in it. And you assess the property transfer tax at that point, and you do that not just because no cash is passing hands here. You assess that tax based on a value that comes out of IRS tables with all kinds of actuarial stuff that goes into a black box, and an answer comes out as to what the appropriate value is of that property given the lifespan and all the rest. And so with these enhanced life estates, you're doing the same thing. However, because I can sell it or I can revoke it before I actually die and the transfer occurs, then you need to set up these times within which the former future owner can get a return on the transfer tax that they paid at the time the life estate was established. So normally they have to do it within 1 year, I assume, of the event. Like I canceled it, but it has to be within 8 years of the formation of, or within 8 years of when they pay the tax.
Right, exactly.
Paid the tax in 2020, they have been, if something goes wrong in 2022, they have until 2028 to file a claim, right?
Exactly. Well, if something goes wrong in 20,
It has to be brought, something has to go to within 1 year. So if I decide I don't like my faithful retainer, she's burning my coffee, I do another life estate, or I just say it's going to probate, or I get remarried and it's going to my new spouse. If that's on the 7th year or the 6th year, they have to file within 1 year of the action that negated the thing. If I don't do any of those bad things until the 9th year, then that person is out. I assume they could always go to court and sue, but there is, because we can't run things out forever.
exactly.
I essentially do this when I was 40 and lived to be 100. Okay.
That was kind of my question. Why 8 years? I mean, I can appreciate some timeline, but if it was 12 years, the state just keeps that money and then waits for the next transfer and collects it again. So why do we have that, and why 8 years in particular?
No, great question. And that was really just a matter of record retention. You know, we were kind of trying to stretch our comfort level with what we could, promise to have on hand at the tax department. Usually, 3 years is the statute of limitation for most things. So it's kind of like our baseline, but thought that given the characteristics of these arrangements, it'd be nice to provide a longer runway. So this was about as long as our legal team who retains said records was comfortable with. So that would be our recommendation.
And why not have the tax due at the actual moment of transfer, when you would have up-to-date value of the property, et cetera?
Well, it's actually the transfer of the deed, which is the taxable, like the deed itself with transferring, which is the taxable event. And that's what happens in the creation of these enhanced life estate deeds. So there'd be no way for the department to so even if we, looked over that, like, okay, we'll treat it differently for these types of arrangements. We don't have another event like that encourages someone to involve the tax department. We have no way to audit that or, check to see when that death occurred.
But doesn't the enhanced, what's it called? Life estate, there must be some kind of execution that gets triggered upon a death, right? Maybe that's a poor choice of words. Some, right?
Yeah.
Like you're saying no, that the deed is already recorded, and then some kind of asterisk gets removed or something.
Yeah, and I'm not even sure about that last asterisk part. I think like the, kind of tax planning motivations for doing something like this probably require that transfer to have happened so that, the person who's still living in the house can, take advantage of those Medicare benefits and, things like that. So it really is this, the intention of this, method is to make it very formal at the deed transfer.
Yeah, it's gonna have to be stapled onto something in the deed in the town clerk's office.
Yeah,
Because he can revoke it.
I get that the deed is the transfer of the deed is the moment, the taxable moment, but there is a thing, I think, that after someone dies and you file their final tax, isn't there something that you have to inform the IRS and presumably the tax department of a death?
We don't require any reporting of.
I haven't informed anybody except the bank that held the mortgage. They kept sending me bills.
I thought there was something about this is the final tax so that they're not expecting another tax return. I don't know. Okay.
If someone owes taxes, their spouses will often file like, the remaining tax return. I have seen those before, but not everyone's a taxpayer, an income taxpayer. It's not something that we get across the board,
Got it.
especially at that age, potentially.
I could be a Canadian and own a condo in Stowe. And
Low income.
And I'm not filing taxes here. But I could set up a life estate for my kid who does live here. Or lives in Canada. Okay, Senator Sorokin.
Thank you, Rebecca. So I guess I wasn't aware of enhanced life estates, but are they valued at the time of transfer the same as a life estate? The only difference is they have the ability to get a rebate or a return?
Right, exactly. Yeah, the exact same methodology for valuing a transfer via a regular life estate is what's proposed, or is what's codified here. It's what we're already doing today.
So, okay. I think we understand.
Yeah.
As well as our question.
Yeah. And I should add that this
Thank
was,
you.
oh, sorry, go ahead.
No, I did say thank you. I think
Yeah.
this, we are definitely more enlightened when we first took this up.
Awesome. I'll just add that the Vermont Bar Association has reviewed this. We sent it around to their listservs over the summer. And I know James Knapp, who at least at that point was the co-chair of the property law section, was supportive of this proposal and had offered to come in on when we were on the House side. So, just happy to help follow up if you guys want to hear from anyone else on this.
Okay. Thank you. And, well,
Great.
Michael was here. Michael's now gone, but I assume they're both here for the same thing. Christopher Herrick, I know, is here. His name is here. There he is.
Good afternoon.
Good afternoon. And why don't you tell us what is in the miscellaneous tax bill that is this, yeah. This is Fish and Wildlife. This is the Native Indigenous Americans free hunting and fishing license, is that?
That's correct. That's what I understand. And so what it would do is allow it expand what we're already doing to allow for free hunting, fishing, trapping, and all the various tags associated with, turkey hunting, so on and so forth. And we do support it, and the impact to our budget would be, we estimate around $13,000 a year. I will note that previously, when they did estimates, the actual cost fell short. So we're pretty comfortable with the number of $13,000. The only concern that I would like to express is that it makes it a bit complicated if the effective date
Kind
is
of
upon.
losing your voice.
Oh, let me do this.
Turn your head like that, we can hear you really well.
Okay, how's that?
That's good.
I think the concern we have with having it be effective upon passage is that our hunting regulations are almost exclusively built around the calendar year. And so it complicates matters in terms of our administrative systems if we do it mid-season. And also it would make our hunting guides, which we issue at the beginning of the year, inaccurate. And so that would be our only concern about this.
When would you have it be effective ideally?
January 1st.
Okay.
Of 23,
Correct.
okay. And that will let you get your new hunting and fishing guides out and have everything synchronized.
That's correct. And it
Okay.
reduces confusion.
And but remember the original presentation, this makes clear that it's not just the license, it's all the tags that go on the license. It's
That's how I'm reading it. Let me just pull up the language.
I thought that's what was where the confusion we were clearing
That
up.
was exactly it. I just want to make sure that it's in there correctly. That was the intent. All, one or all the permanent fishing, hunting, trapping licenses set forth. That's broad enough to cover it.
Okay. If you find anything, this bill is probably not gonna fly out of here in the next 2-3 days, so.
Okay. Yeah, we'll take another, we'll scrutinize it one more time and I'll let you know.
You haven't decorated this bill at all, and I'm
Not
just,
yet.
not yet. I'm feeling, this is my favorite Christmas tree, and we decided to put
Got the
anything
holiday
on it
spirit,
this year.
do you?
Just probably the first time ever, but we've got another week or two.
Okay.
Mr. Brady, anything you have to add?
Yes,
Oh, okay.
so Abby was in here the last time when there was a presentation and she said, or you, I'm not sure whom, but you as a commissioner
One of us who will remain unnamed, and we probably can't remember.
had a couple of questions. And the first question was, what is covered now and what would be covered under the proposed change? And so, glasses. So currently, under the existing pre-license, they get a free permanent fishing license, or if they qualify, they get a free hunting license, a free permanent combination hunting and fishing license. So that's current. Under the proposed language, they get a permanent fishing license, a hunting license, a permanent combination fishing and hunting license, which includes all big game licenses except for a moose. And then if the person qualifies for a trapping license, they get a trapping license. If the person qualifies for an archery license, they get an archery license. So really the only tag that they don't get is the moose tag. And that's because it varies significantly from year to year in the health of the herd.
And it's very limited. Okay,
So they would still have to, I'm sorry, Madam Chair, they would still have to apply for the moose tag? Or
They would
go
still have
into
to
the
apply for the
line?
moose tag, but they wouldn't have to apply for a bear tag, they wouldn't have to apply for any additional deer tags, they wouldn't have to apply for a turkey tag. They wouldn't have to, with that, so that's, they get all those.
And they would have to still meet all this, or they do already have to meet all the other requirements?
Right, you have to be qualified, hunter safety, et cetera.
Yeah, okay.
here's
For the, if they wanted a moose tag, do they then have to pay for that?
Yes.
So the way it currently is, everybody has to put in for the lottery, which is like $10 or something. And then if you're drawn, you pay additional fees.
Alright.
It's because moose are special, you're trying to.
Well,
do like that for-
it's a different, well, there's lotteries for
Yeah.
non-residents, but it's a lottery and it's a different system.
Yeah, no, I was just wondering that there's the cost and then there's the ability to get one in the moose situation. I
Yeah.
was wondering if folks had delineated, but
You do give away a couple of moose licenses a year, but it's pretty limited.
Yeah. And the moose, from what I've read, they were growing, the size of the herd was growing. I haven't heard stories of moose in downtown Montpelier in quite a few years, and they were not uncommon, maybe 10 years ago. They haven't shown up in my backyard, but I thought the ticks were definitely
Right,
decreasing the population.
Yeah.
So we're watching it.
So that's accurate, generally speaking, in the two wildlife management units up in the Northeast Kingdom, E and E1, where we have an overabundance of moose per square mile. The rest of the state is right about where we want them, and so we're not even allowing any hunting in those sections.
Okay.
Michael, what about the effective date thing? Can we just change that?
Yeah, that's
Is there
not
an
a
issue?
problem. And I believe Senator Hardy, when Abby was in, she noted, or you noted, that it doesn't say for free anymore. And I don't know how that happened, but it does need to say.
Oh, so we should add for free?
For free. So
Okay.
it would probably need to, for grammar's sake, say a certified citizen of a Native American Indian tribe that's been recognized by the state may receive for free one or all of the permanent fishing, hunting, or trapping licenses set forth in subdivisions 1A through D.
You can say free of charge, that would be more dramatic.
Sure, you can say for free
Classy.
of charge.
That would be classier.
That would be classier.
Do the classy version, Michael.
Well, I think if it's on the front lawn and threatening your house, you can shoot it, but then you gotta get it off the front lawn.
A moose threatening your house? Does that?
No.
I
And I
don't,
have that one in my backyard.
so those are the two changes. I can make the effective date change to January 1, 2023. And then I can make that clarifying change. I don't know how you're making changes for 738. Are you gonna do a strike all or instance by instance?
Haven't gotten that far. I think we may end up doing a strike all, just looking at the amount of notes I've got, but, you know, it's up to the drafters what they think is easier.
Okay,
Um,
I will consult with Abby.
And we do a lot of amendments to add things, but so far these are more like technical or clarifying corrections, so. We'll see what we end up with, and then I don't know who the drafter is on this, Abby, I guess. We will ask Abby what we should do,
Okay,
okay?
great.
But,
Thank you.
yeah, just add those in. Okay,
Nice to see you, Michael. Nice to see you.
Nice to see you all.
Thank you all. All set with me?
thank you.
Super.
Okay.
Get to the rest of the day, really easy. So, thank you. That is it, committee. We are back on the floor to do the budget in a few minutes, so we can go off live and start heading upstairs.